This is page 214, Constitution Handbook. For more than 200 years, the Constitution has provided the framework for the United States government and has helped preserve the basic rights of American citizens. It is the highest authority in the nation and the basic law of the United States. It is also a symbol of our nation, representing our system of government and our basic ideals such as liberty and freedom. The Constitution, main idea. The Constitution sets forth the basic principles of government. History and you. What principles do you live by? Read to learn how the basic principles of the Constitution assure the rights of the people. The Preamble, or introduction to the Constitution, reflects the basic idea of American government, the right of the people to govern themselves. It also lists 6 goals for the United States government. Primary source: to form a more perfect union, establish justice, ensure domestic tranquility or peace, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, or our descendants. United States Constitution. Major principles. The principles outlined in the Constitution were the framers' solution to the problems of a representative government. The Constitution rests on 7 major principles. 1. Popular sovereignty. 2. Republicanism. 3. Limited government. 4. Federalism. 5. Separation of powers. 6. Checks and balances. And 7. Individual rights. Popular sovereignty. The Declaration of Independence states that governments derive their powers from the consent of the governed. The opening words of the Constitution, "We the people," reinforce the idea of popular sovereignty or authority of the people. Republicanism. Under republicanism, voters hold sovereign power. The people elect representatives and give them the responsibility to make laws and conduct government. For most Americans today, the terms republic and representative democracy mean the same thing: a system of limited government in which the people are the ultimate source of governmental power. Limited government. The framers saw both benefits and risks in creating a powerful national government. They agreed that the nation needed strong central authority, but feared misuse of power. They wanted to prevent the government from using its power to give one group special advantages or to deprive other groups of its rights. By creating a limited government, they made certain the government would have only those powers granted by the people. Article 1 of the Constitution states the powers that the government has and the powers that it does not have. Other limits on government appear in the Bill of Rights, which guarantees certain rights and liberties to the people. Limited government can be described as the rule of law. No person or group of people is above the law. Government officials must obey the law. Federalism. When the states banded together under the Constitution, they gave up some independence. States could no longer print their own money or tax items imported from other states. Nevertheless, each state governed itself much as it had in the past. This system, in which the power to govern is shared between the national government and the states, is called the federal system, or federalism. Our federal system allows the people of each state to deal with their needs in their own way. At the same time, it lets the states act together to deal with matters that affect all Americans. The Constitution defines 3 types of government powers. Enumerated powers belong only to the federal government. These include the power to coin money, regulate interstate and foreign trade, maintain the armed forces, and create federal courts, Article 1, Section 8. The second kind of powers are those retained by the states, known as reserved powers. They include such rights as the power to establish schools, pass marriage and divorce laws, and regulate trade within a state. Although reserved powers are not listed specifically in the Constitution, the 10th Amendment says that all powers not specifically granted to the federal government are reserved to the states. The third set of powers defined by the Constitution are concurrent powers, shared by the state and federal governments. Among these powers are the right to raise taxes, borrow money, provide for the public welfare, and administer criminal justice. When conflicts arise between state law and federal law, the Constitution declares that the Constitution is the supreme law of the land. Conflicts between state law and federal law must be settled in a federal court. Separation of powers. To prevent any single group or institution in government from gaining too much authority, the framers divided the federal government into three branches: legislative, executive, and judicial. Each branch has its own functions and powers. The legislative branch, Congress, makes the laws. The executive branch, headed by the president, carries out the laws. The judicial branch, consisting of the Supreme Court and other federal courts, interpret and applies the laws. Checks and balances. As an additional safeguard, the framers established a system of checks and balances in which each branch of government can check or limit the power of the other branches. This system helps maintain a balance in the power of the three branches. For example, Congress can pass a law. Then the president can reject the law by vetoing it. However, Congress can override or reverse the president's veto if 2/3 of the members of both houses vote again to approve the law. Over the years, the Supreme Court has acquired the power to determine the meaning of the Constitution and to declare that a law or a government policy goes against the Constitution. In doing so, the court provides a check on the powers of Congress and the president. Judicial decisions, those made by the courts, can be overruled by amending the Constitution. The president and the Senate provide a check on the judicial branch through their power to appoint and approve federal judges. Congress can also change a law so that it no longer conflicts with the Constitution, or it can amend the Constitution. The 14th Amendment, passed by Congress in 1866, overturned the Supreme Court's ruling in the Dred Scott decision, which had ruled that enslaved African Americans were not citizens. Individual rights. The Bill of Rights became part of the U.S. Constitution in 1791. These first 10 constitutional amendments protect basic liberties and rights that you may have taken for granted, including freedom of speech, freedom of the press, freedom of assembly, freedom of religion, and the right to a trial by jury. The 17 amendments that follow the Bill of Rights expand the rights of Americans and adjust certain provisions of the Constitution. Included among them are amendments that abolish slavery, define citizenship, guarantee the right to vote to all citizens aged 18 years and older, authorize an income tax, establish the direct election of senators, and set a 2-term limit on the presidency. We'll conclude there.